The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about estate planning for business owners. First, we'll explain what estate planning is and what you can accomplish with it generally. And then we'll go into some special considerations that business owners should think about when planning for their estate. So first, what is estate planning? It's basically providing for a smooth transition for your loved ones if you pass away or become mentally incompetent. It can be providing for how your assets will be distributed to beneficiaries or how they'll be managed if your beneficiaries might be so young that you don't want them to receive a lump sum of money right away. It might be providing to avoid probate. Probate is a year-long court case that generally, if you don't have an estate plan, is necessary in order to give your executor the power to collect the assets of your estate and distribute them to beneficiaries. It costs a lot of money in attorney's fees, and it can be very stressful for everyone involved, and it takes a year for your beneficiaries to receive your assets. So we want to avoid it, and with a good estate plan, you can do that. Another consideration is minimizing or avoiding estate tax. Also, making sure that you're properly insured so that your loved ones are taken care of when you pass away or if you become mentally incompetent, and making sure that your loved ones are properly listed as beneficiaries on your insurance and retirement accounts. It's providing for what's going to happen if you become mentally incompetent. You can do this through powers of attorney and give the right people the power to act on your behalf if you're no longer able to do so that a guardianship proceeding won't be necessary. And we want to avoid guardianship proceedings for the same reason we want to avoid probate, because they're costly, stressful, and take a while before the people that need to can start acting on your behalf. And finally, it's providing for end-of-life decisions. So if you are in an irreversible coma, do you want your loved ones to make a decision as to whether to terminate life support, or do you want to take that decision out of their hands? So that's the main things that you can do with an estate plan. And there's some other things too, but those are the common considerations. But business owners have some special considerations that they should think about when working on their estate plan. One is using a buy-sell agreement if you have multiple partners in your business. So if you are a sole shareholder in your business, then you don't need to worry about a buy-sell agreement. But if you have multiple partners, you really don't want a situation where if one of you passes away, the remaining partners are going to have to do business with the spouse or children or heirs of the deceased partner. Or if a partner becomes disabled, you want to provide for that situation. So what a buy-sell agreement does is it says that the remaining partners will buy the shares of the deceased or disabled owner from the estate of the deceased or disabled owner at a agreed upon price. Now, this might be a fixed price that you state in the agreement, or more likely, it's going to be an industry-specific formula or fair market value, which can be determined by an appraisal. So basically, you're providing that if one of you passes away or becomes disabled, the spouse or children of the disabled business owner aren't going to have to learn to manage the business or negotiate a deal to sell the shares at an uncertain price. You are setting a price for the purchase of the deceased owner's shares. Now, the scary thing about this is that the remaining owners have to come up with the money to buy the shares. And so usually what will happen is that the company will buy insurance on the lives of all of the owners, and then the company gets paid out when one of the owners dies from that policy, and it will use the proceeds of that policy to pay the estate of the deceased person for their shares. So everyone's happy. The remaining owners don't have to do business with the spouse or children of the deceased owner, and the spouse or children of the deceased owner, or whoever the estate or heirs are, get a lump sum payment for a fair value without having to find a way to sell those closely held business interests, which can be really hard to sell, or do business with the remaining owners. So that's what a buy-sell agreement is, and it's something that everyone that is in business with a couple of people or a small business that is not a sole shareholder should think about. Alternatively, if you are a sole shareholder or the majority shareholder in your business, you will probably want to provide for the management of the business after you pass. So one thing you can do is, if you want the person that you're naming as executor in your will or trustee of your trust to be the person managing the business, then the easiest thing to do is provide explicitly in your will or trust that they have the authority to manage the business affairs once they're appointed as executor or trustee. or even before they're appointed as executor. And this will save them the effort and time of going into court to get an order explicitly giving them the authority to manage the business, and it'll allow them to take immediate action after you pass away. If your executor or trustee are not the people that you want to manage your business, then you can appoint a special business advisor in your will or trust that will have the authority to manage the business while it's part of the estate. And then this has the upside of having the right person that knows your industry, managing the business effectively, because whoever you have as your trustee or executor may not be in your line of work. But it also has the advantage of not having the trustees or executors' attention divided between managing the estate and managing a business that just lost a key person. So you really don't want that to happen because that's not going to be good for the estate or the business. So if you're a sole shareholder, appointing a business advisor that will have authority over the business is a really good idea. Making sure your business avoids probate is another big thing. So a lot of business owners think that if they put their savings accounts or their real estate into a trust, probate will be avoided, but that's not really the case if their business is not properly held. So probate is necessary in Illinois when you own any real estate outside of a trust or outside of a deed that provides for rights of joint survivorship, or if you own $100,000 or more in assets of any type outside of a trust or outside of payable on death accounts, so accounts that name a direct beneficiary that will receive the account when the owner passes away. So a business is subject to those rules too. So whatever the fair market value of your business is gets added in when you're figuring out whether there's $100,000 outside of a trust. So if you want to make sure that your business and the rest of your assets don't go through probate, which, like we said earlier, it will suck a lot of money out of your estate, especially if you have a business that has to be managed in probate, and be stressful for everyone involved. What you do is, rather than owning the shares of your business in your individual name, you have them owned by your revocable living trust. You don't really lose any power over the business, but what that does is it makes sure that your business doesn't cause your estate to go through probate, and everything can be passed immediately, usually without an attorney, to your heirs or beneficiaries. One thing to be aware of is that S-corps have certain limitations on the types of trusts that can own the S-corp. So you want to make sure you work with an attorney to make sure your trust is set up in such a way that it's allowed to own the S-corp. Not a big deal unless you don't think about it. It's not hard to do. It's just something that you need to work with an attorney to make sure you get right. Otherwise, you might lose your S-corp status, which is a big tax benefit that you don't want to lose. Next, let's talk about estate tax planning. So for anyone that is approaching $4 million in assets, including the value of your business and the death benefit of life insurance policies, estate tax is a concern. In Illinois, estate tax is applied to assets over and above $4 million in an estate, and it can be a pretty large tax. So there's a lot of different strategies that we're not going to get into in this video about how to avoid estate tax or minimize it. And we certainly want to think about all of them if we're a business owner. And it's very fact-specific and need-specific based on your asset structure, what strategies you employ first. But one that is a great one for business owners is something called GRITs, GRATs, and GROOTs. And this is grantor-retained income trusts, grantor-retained unit trusts, and grantor-retained annuity trusts. And we have an article and video about GRITs, GRATs, and GROOTs. But the bottom line is it's a way to make sure that you can put your business into one of these irrevocable trusts, and from the time that you put it in, any increase in value will not be part of your estate for tax purposes. Whatever the value of your business is when you put it in the trust is generally part of your estate, but it allows your business to increase in value with the increased value of your business not being part of your taxable estate, and it allows you to transfer that to your next generation or your beneficiaries, your loved ones, without being subject to gift tax or estate tax. Now, there's a lot of complicated things going on with GRITs, GRATs, and GROOTs, but one other advantage is that you can receive income or annuity or some fixed amount every year from your business while it's in this trust. And so you can still get some benefits that you want out of income from your business while maintaining some control over your business and removing it from your taxable estate. But again, that's a little bit more complex than we want to get into here, so you should check out our video and article at learn-about-law.com about grits, grats, and groots if you'd like to learn more about that. Finally, we'll talk about protecting your personal assets from business creditors. This is an important thing for business owners because business owners tend to accrue liability in life more than people who work for someone else. So just incorporating either as an S Corp or an LLC will by default, protect your personal assets from business creditors. However, in a small business, you're often asked to personally guarantee things like lines of credit, loans, leases. So anything that you personally guarantee is not going to be protected from business debts. So, or any debts that you personally guarantee, the creditor can come after your personal assets, rather. So what we want to do here is do an extra layer of creditor protection other than just incorporating your business to protect the assets that you value most from any creditors that might come after you from your business debts. And you can do this with irrevocable trusts and family limited partnerships. And a lot of people will transfer their family home into a family limited partnership or irrevocable trust in order to protect it from their business creditors. So if you want to learn more about that, again, we have an article and video about creditor protection, but that's something that business owners in particular should be thinking about. And the point that we're going to talk about now is just alerting you that there are things that you can do to protect your personal assets from your business creditors, especially when you're personally guaranteeing things and it's over and above just incorporating. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.